Good morning, afternoon, or evening to you wherever you're currently located in the world. Welcome to today's Data Guidance webinar presentation. My name is Toks and I am part of the Europe, Middle East, and Africa analyst team here at Data Guidance's London headquarters. I'm very pleased to be hosting today's session entitled Bahrain Personal Data Protection Law. For the next hour or so, we'll be discussing the historic and highly significant personal data protection law. The first part of the webinar will consist of a panel discussion, and in the last 20 minutes of the webinar, you'll have an opportunity to send across your questions to the panel. Indeed, you may do so using the software with which you are currently logged on. And of course, you are encouraged to send your questions. By way of context, on 12th July 2018, the Kingdom of Bahrain issued Law number 30 of 2018 on the Personal Data Protection Law. For the sake of simplicity, we shall abbreviate the law to PDPL. The PDPL will enter into force on 1st August 2019. In this webinar, we will be talking about a few things. Firstly, the background, what the DPL is about, its main features, the role of the Data Protection Authority, PDPL versus GDPR, its impact on businesses, how to be prepared, future predictions, and of course, the Q&A. I am very pleased to have with me today as guest speakers Mohammed Tirani and Eamon Holly, both from the law firm DLA Piper. Mohammed Tirani is a legal director and the head of DLA Piper's Bahrain office. He has over 11 years of legal experience and advises on a broad range of corporate and finance matters, including, among other things, corporate governance, joint ventures, employment, and investments under Bahrain, UAE, and UK law. In addition, Mohammed has recently been appointed by Bahrain's Minister of Justice as one of 4 private notaries in Bahrain. Eamon Holly. Eamon Holly is a legal director, intellectual property and technology, based in DLA Piper, Dubai. He is a leading telecommunications, technology, and data lawyer in the Middle East, and regularly advises both government bodies and private sector clients in relation to the United Arab Emirates, UAE, Bahrain, Qatar, Oman, and Saudi Arabia. Eamon has been highly ranked by various legal directories for his work in TMT and data protection. Between 2007 to 2012, Eamon worked for Bahrain's Telecommunications Regulatory Authority as the Director of Legal Affairs. Now, to kick us off, Mohammed, I'd like to invite you to tell us a bit more about the background to the PDPL. In particular, what led Bahrain to this point?
Thank you, Toks, for a pleasant introduction. Well, first of all, as you briefed it out, the PDPL is part of a suite of economic reform laws in Bahrain. Bahrain has recently introduced new regulations and laws. Amongst those regulations and laws that were introduced are competition law, insolvency law, bankruptcy law, and health insurance law. Now, part of Vision 2030 in Bahrain, they've introduced a lot of regulations and laws and policies to make Bahrain, to bring Bahrain to a certain level and standard and becoming more of a developed country and having a more developed legal system. Now, prior to the PDPL, there was no general data protection law in Bahrain. It was basically a number of provisions that protect privacy in various laws in Bahrain. Those laws were Penal Code, Central Bahrain regulations, telecommunications law, amongst other TRA regulations. These rights are also underpinned by the Constitution of Bahrain, which guarantees that the right to privacy of communication is subject to exigencies of the law. Now, there was an outcry to have a standalone data protection laws, and the parliament in Bahrain have decided a few years ago that Bahrain, moving forward, Bahrain should have a standalone data protection laws, and as a result, PDPL was issued, comes into force August 2019, later this year.
Thank you very much, Mohammed. Now, I wondered, for our listeners who may not be familiar with the PDPL, could you give us a sense of what the PDPL is about, please?
Well, the PDPL basically, it's basically, in a nutshell, it is to protect data privacy and privacy of individuals, company records, information, to be regulated. Now, I wouldn't say it was unregulated before. I just think it was more broad. It was not specific and as strict. Let's say there was not a tight grip on how to govern data and information prior to the PDPL's issuance. So now with the PDPL is in place, individuals, companies operating in Bahrain can now believe that their interests are best safeguarded with the PDPL being issued.
Thank you very much for that. Now, can I invite you, Eamon, to take us through the technical aspects of the PDPL? What are its main features?
Thanks, Toks. Yeah, as Mohammed mentioned, the PDPL is a personal data protection law. Its primary focus is to introduce rights to data subjects, although in the PDPL they're referred to as data owners, to protect the way personal data is managed, collected, stored and processed, etc. So in many ways, it is very similar to data protection laws that you'll see around the world, including, the general data protection regulation of Europe. But as we'll see later on, it does contain some additional and unique provisions that listeners may not be familiar with in other data protection laws, but which we, at least in the Middle East, often see in other provisions. So, as you'd expect, it contains specific obligations on data controllers. Again, the term used in the PDPL is slightly different. They refer here to data managers, not data controllers, but for the purposes of today's conversation, we'll just continue referring to them as data controllers. So, for example, in terms of how they collect data, whether or not, how they do that on a principled basis, the requirement to provide notifications, etc., to data subjects as and when the data is collected and used. It also provides rights to data subjects. So again, as we'll see later on, some of these are very similar in nature to the data subject rights you will see in most data protection laws around the world, including the GDPR. But again, there are some additional data subject rights that we are not familiar with from those laws. As Mohammed mentioned, this law applies to persons who are resident in Bahrain and to businesses that are based in Bahrain. It is extraterritorial in the sense that it also applies to persons who are not resident or businesses that are not based in Bahrain if they are using a means of processing in Bahrain, which is not used for transit only. So it's not entirely clear what this means. It's different in scope from, say, the GDPR and Article 3 of the GDPR, the extraterritoriality obligations there. But it seems to be capturing people or businesses that will use data processes, for example, that might be established in Bahrain. However, it's not clear whether or not it will capture entities, for example, providing services or goods remotely into Bahrain or otherwise monitoring people's behavior like the GDPR does. The PDPL also requires that there will be a data protection authority. We'll talk a little bit later on about some of the powers that the DPA, or authority rather, has or will have. It's important to note that the DPA isn't established yet. as far as we know. Another point to mention is that the data protection law requires that the authority will issue a number of regulations to implement the law. Now, these were supposed to be published at the end of January, but as far as we know, to date, they don't appear to have been. So it's something to keep an eye out on. Things that, the sorts of rules that the authority needs to publish under the law include procedures around processing special categories of data, so sensitive personal data, rules in relation to how to preserve confidentiality. They have the ability to publish technical and organizational measures to protect and secure data. They have requirements to outline data protection officers' activities in terms and conditions to satisfy registration requirements and so forth. So there's quite a bit of, and that's just some of the functions that the authority needs to regulate for. So there's quite a bit of work that seems to need to be done before the implementation date of 1 August. So if you could turn to the next slide, please. So again, this is just indicative of the obligations that data controllers, or as I refer to here, data managers, need to comply with. And anybody familiar with data protection laws, and in particular the GDPR, will see these and see a lot of familiarity. So starting at the very, very top, the PDPL contains requirements on controllers to process data in a fair and legitimate manner, that it needs to be collected for legitimate and specific purposes, that the data collected should be sufficient, not excessive for the purpose that it's collected for. The data should be correct and accurate and subject to updates whenever possible, and that it needs to be kept in a form that allows the identification of the data owner after the purpose of the collection has been met. So those things, again, are very familiar to most people who are familiar with data protection laws. And there again, the controller needs to ensure that once the data has been collected properly, that it's processed in a fair manner as well. And so again, we'll see many of the same bases for processing as we see in other data protection laws. So processing should only occur with either the consent of the owner of the data or the data subject, unless it's necessary for implementing a contract with the data subject, or to take steps at the data subject request to conclude a contract, or otherwise to comply with an obligation under law, to protect the vital interests of the data owner, or to exercise legitimate interests, bearing in mind the fundamental rights and freedoms of the data subject. So again, all the same things that we see under the GDPR and many other data protection laws are caught here in the PDPL. Data controllers need to provide data subjects with notices, both when they receive data directly and indirectly. There are slight differences in terms of the timeframes within which that needs to be done. So, as expected, when data is collected directly, notification needs to be provided at the time of the collection. But when data is received indirectly, the notification needs to occur, I think, within 5 days after the processing commences. There's an obligation on the control to respect the data subject rights that we will talk a little bit about later on. Interestingly, there's a notification requirement under this law. So, meaning that data controllers need to notify the authority when they intend to start processing personal data. Now, again, for people in the region, the GCC region, this will not come as a surprise, and there are a number of data processing regimes that require notification. So, for example, the DIFC in Dubai, but it's not something that is now currently required under the GDPR. And so this is still something that data controllers locally within Bahrain, but also foreign data controllers that are operating in Bahrain will need to bear in mind. There's additionally a requirement not only to provide notification to the authority, but also to obtain consent from the authority or approval from the authority in the event that a controller wants to process certain sensitive data on an automated basis. So, for example, if the controller wants to process data relating to genetic or biometric information, they'll need consent or authorization from the authority in advance. There are similar obligations in relation to whether or not to appoint a data protection officer in the PDPL as there are, say, in the GDPR. Again, the name is slightly different. In the PDPL, we refer to the data protection supervisor rather than a data protection officer, but by and large, the requirements are the same. The authority has the power to identify what types of controllers may need to appoint a data protection supervisor. So for the most part, it will be a voluntary issue, but in some cases, again, to be determined by the authority, which is yet to be set up, there will be a requirement to appoint a data protection supervisor. But in all cases, whether voluntary or compulsory, the authority will keep a registry of data protection supervisors. So there will be a list, which I think will be publicly available, of the relevant people who are data protection supervisors for specific controllers. And as you'd expect, there will be transfer obligations in relation to transferring data from Bahrain to third countries, or to countries or jurisdictions outside of Bahrain. The Data Protection Authority needs to identify, or has the power rather, to identify a list of countries with adequate protections. Obviously, this hasn't happened yet, and we're not sure whether it will just adopt, for example, a list from Europe or the DIFC. It remains to be seen. But despite that, if a third country is not on the list, then compliance with the PDPL will be required, and that can include obtaining consent from the authority on a case-by-case basis, or otherwise entering into model clauses, which again yet need to be developed by the authority. So, by and large, a lot of this is the same as data protection laws you'll see elsewhere. Next slide, please. Now, there are some nuances, and we can talk about some of the differences a little bit later on, but the PDPL does require that data be kept secure, and that data controllers secure data in using technical and operational measures, which the authority appears to be able to dictate. Interestingly, though, the law does not contain a breach notification requirement, which is unusual. It remains to be seen whether or not the authority seeks to try to require notification, say, for example, in the implementation regulations, but we would expect that might be a bit too broad, but we will see if they attempt to do that. And as I referred to earlier, the law also establishes a number of data subject rights, some of which, again, look familiar and very similar to the rights that we've seen in Europe for a while and under the GDPR now, so a right to demand rectification, to block processing, or to erase data. But there are also a number of other data subject rights. So, for example, a specific right to object to direct marketing, as well as an obligation on the controller to notify the subject that it will be direct marketing to them. Data subjects can also object to automated processing. Remember again that automated processing in some circumstances needs to be approved by the authority. But the data subject right that might sort of stick out for most readers if they're not familiar with the region is a right to object to processing of personal data that causes harm or distress to either the data subject or another person. So this is a very wide right. It's not clear how it would be proven or how it will be applied. But for those of us who've worked in the region for a while or are familiar with the laws, this is not totally surprising. So a number of penal laws around the region will have prohibitions against invading, for example, privacy of family life, and allow for prosecutions for example, photographs taken of family without consent that might be, for example, shared online. So this is not dissimilar to those sorts of laws, and we think that this is just a continuation of that sort of culture, effectively. Next slide.
You mentioned the Data Protection Authority, Eamon. I just wondered if you could tell us, the listeners, the role of the Data Protection Authority.
Sure. So it's as I said earlier, it's not established just yet, as far as we know. Sometimes these things occur in the background without any or too much public knowledge until the announcements are made. But the authority, as you'd expect, will have oversight of the PDPL. It, as I mentioned earlier, needs to issue a number of regulations to implement the PDPL. So there's quite a bit of work for it to do immediately, and we think prior to the 1st of August. As you'd expect, it has a supervisory and enforcement role. So the authority will be able to investigate allegations of breaches, either voluntarily or upon receipt of a complaint, and has a number of powers then in terms of enforcement. So, for example, the law allows for penalties of 1,000 Bahraini dinars a day, or up to 2,000 Bahraini dinars a day if it's a second similar breach within 3 years of the first breach. It can issue administrative penalties of up to 20,000 Bahraini dinar. It allows for compensation claims to be made by those persons who are affected by allegations. But it also allows, and this is not something that the authority would do, but it may allow referrals to prosecutions to occur. The law also allows for criminal penalties for breaches. And so it would be expected that the authority would be, for example, when investigating the PDPL and an allegation of breach, if it identifies that one of the articles which allows for penalty or criminal prosecution has been breached, that it will refer the matter to the public prosecution in Bahrain. So it's quite an extensive role. But equally, in the context of Bahrain and the region, it's one that's quite familiar to us.
Thank you very much, Eamon. As our listeners undoubtedly know, last year, on the 25th of May, 2018, of course, the General Data Protection Regulation came into force. And I'm sure our listeners are quite eager to know how the PDPL compares with the GDPR. So what is the answer?
Sure. So I think, well, we've covered most of them already, I think. So by and large, there's more similarities than there are differences. But the differences, I think, are quite large. So the examples we've just given include that there's a requirement that data controllers, data managers obtain authorization from the authority for automatic processing of certain data. There's the requirement that the data managers, data controllers need to notify the authority in the first place of their controlling or of their processing. Another difference is the criminal sanctions that I've just mentioned. This is something that we've not seen or doesn't exist under the GDPR itself, although, of course, member states may have their own rules, which violation of the GDPR may also equate to criminal breaches in those specific jurisdictions. The right that I just mentioned in relation to objecting to processing of personal data that causes harm or distress is something that's quite unique and needs to be considered very carefully. And yeah, so by and large, I mean, those would be, I think, the major differences. And of course, what we have to see is how the authority will apply the law as well. So enforcement, application enforcement is very important, obviously.
Thank you. So let's now talk about the expected impact on businesses. What do you reckon that might be?
Sure. So, the UAE, sorry, the Bahrain, the UAE, Saudi, the region generally has not had to date a data protection culture in business. So there are quite extensive and quite far-reaching provisions in penal codes that protect individuals' privacy from abuse. And they allow for prosecution and fines in some cases. So what I think we'll see is a transition from local businesses and regional businesses in particular. I mean, they've already become aware or alive to these issues primarily through the GDPR and the application of that on an extraterritorial basis. So I think there'll be quite a significant impact in terms of the way businesses behave, in the way that they treat personal data on a regional and local level. And I think as well, local data subjects or people, individuals regionally will also become alive to the rights, and this will make business for businesses a little bit different to what it used to be like. Mohammed, do you have any other views?
Yeah, Eamon, I agree. The PDPL will provide individuals with rights in relation to how their personal data can be collected, processed, and stored. So as a knock-on effect, it will impose new obligations on how businesses would manage those personal data, including, I would say, ensuring that personal data is processed fairly. Data owners will be notified of their personal data when it's collected, processed, and they can exercise their rights directly with the businesses. So all in all, it's a very, very much positive outcome to individuals, and they can rest assured that their data will be protected, serve more protection to them in the long run.
Thank you very much. Now let's consider what businesses can do to prepare for the PDPL. Let's start with Eamon.
Sure. Thanks, Toks. So we, over the last year, 2 years, have been working closely with a lot of businesses regionally in terms of compliance with the GDPR. And we have developed effectively a fairly straightforward process for working with and guiding businesses through the compliance journey. But the very first step that needs to be taken is an assessment of the data processing protocols. And by that I mean sitting down with the various business units of the business and figuring out how it is that they collect data, what they do with it, what they think they do with it, where they think they store it, how they think they share it, etc., how they think they process it. And the reason I say think is because quite often we find that when businesses start this journey, they initially think that they have quite a straightforward way of dealing with data in and data out and where it's stored. But during the course of the examination, they might figure out that, in fact, there's a much broader scope of things that they do than they initially thought about, particularly when it comes to complying with a data protection law. So step one is conducting that audit in terms of just sitting down and doing effectively a brain dump on what it is that the business does in terms of the data journey. So taking it from a customer or an employee, where the data is kept within the organization, who manages it, is it stored with themselves or a third party, is it transferred overseas, is it analyzed for the purposes of the business, how long is it retained for, et cetera, before deletion. All of that needs to be considered. Once that's done, then you need to take effectively a gap analysis of what you do with the data, what your current policies are to the extent you have any, and how they fit against the obligations under the law. So, for example, do you have a privacy policy that will explain to a user or a data subject the ways in which you will manage data, how you collect it, how you store it, et cetera, as well as explain to them their rights. and once that analysis is done, and there's been that gap analysis of what we do and what we need to do, then you fill in the gaps by preparing the necessary legal and regulatory framework. So, for example, developing your privacy policy, or ensuring that your contracts with vendors meet any specific obligations that you might need to enter into for the purposes of appointing them, and so forth. So it's quite a complex journey, but equally it's not the same for everybody. So a large business will have greater compliance obligations and risks than a medium or a small-sized business. And even between businesses from sector to sector, there will be differences depending upon how their business collects data and what it does with it. So while the broad sort of steps are the same, each project is a very different thing, and it's not like one size can fit all.
Thank you very much. Mohammed, you very helpfully started this webinar with a history and the background of data protection within Bahrain. Could you just give us some of your predictions on what the future of data protection might be in Bahrain?
Well, thanks, Toks. Well, it all depends, because a lot of let's segregate the businesses on the international M&Es that are in Bahrain and the local businesses. Now, the tricky part will be for the local business to understand how to implement and prepare themselves, because the international companies and M&Es and conglomerates are already, let's say, aware of what they might expect from the PDPL once the regulations are out and it comes into force, the law, in August, because they've gone through it historically with the GDPR. Now, and other data protection laws globally. Now, for local businesses, the tricky part will be is that they won't have the necessary know-how, so they will need guidance, and a lot of companies, as I'm seeing, are looking to recruit data officers as well. So it is an exciting time for businesses in Bahrain. At the same time, there's a lot of question marks on how it will be implemented and how fast it will be implemented in the long run for businesses in Bahrain.
Thank you. And Eamon, what are your thoughts? Any predictions on the future of data protection within Bahrain?
So, yeah, Bahrain has, over the last decade and a half, 2 decades, taken great steps in terms of diversifying its economy. So, for example, taking steps to liberalize its telecoms sector, introducing an electronic transactions law with an electronic commerce and signatures law. And data protection is, I think, the next obvious step. So at each stage of Bahrain's liberalization journey, it has published regulations but actively enforced them as well. And so I think that what we'll see is, hopefully we'll see Bahrain taking an active measure to enforce this law in a way that is meaningful for data subjects and supports data protection, because that will be good for itself and for business and for data subjects, and ultimately for investment into the country.
Well, thank you very much, Mohammed and Eamon. That's been very helpful and very insightful. This now concludes the discussion part of the webinar. I'd like to invite you, our listeners, to address your questions to our speakers. You can do so, of course, by sending a message through this platform, the software. To kick us off, we have a question on the Telecommunications Law 2002 in Bahrain. So the question is, will the Telecommunications Law 2002 continue to regulate data protection in the telecommunications sector?
Sure. Yeah, I'm happy to take this one. I think the answer is yes, it appears to. So the PDPL is a general law, applies to all sectors of Bahrain. It doesn't appear to exclude certain sectors, say, for example, the telco law. The telecoms law of Bahrain and the Telecommunications Authority has had a history of protecting consumer information in the context of the Bahraini telecom sector. So I would expect it continues to do that, and they'll do that in parallel with the authority. But it remains to be seen if maybe there'll be some handover, for example, from the TRA to the authority more generally. Mohammed, do you have any views on that?
Yeah, I agree completely. One thing is for sure that telecoms regulations law should not contradict the provisions in the PDPL. So that will be interesting to see in the long run as well.
Thank you. So we have another question here, which is about the relevant guidance. It says, authorities were expected to issue additional decisions to provide guidance on the application of the law by February 2019. Do you have any updates?
Ayman, honestly, from my side, we haven't yet had any update. However, having said that, the authorities are working on it. I'm aware that they are working on it behind the scenes. So we'll just have to wait and see. Same applies to the Data Protection Authority. I know they're in the process of establishing the authority, but nothing official has been said yet on it.
Okay. Question 3. If you have already conducted a compliance project centered on the GDPR, are we to do the same for PDPL?
Yeah, this is Ayman. So yes, I would still recommend you do that. So as we mentioned earlier, compliance with the GDPR won't automatically mean that you are compliant with the PDPL. You may have a framework in place that is by and large compliant or consistent with the PDPL, but as I just mentioned, there will be nuances that you'll need to be careful with. And so, for example, if you have a data subject request procedure that you've developed to comply with the GDPR, that's well and good and will probably still work for the Bahraini PDPL. But as you mentioned, there are some extra or additional subject rights that you won't see in the GDPR, and it would be worth then developing your procedures to adapt for that under the Bahraini data protection law as well. So shorthand answer is you should be able to take what you've got and probably by and large recycle it, but you just need to make sure that any gaps that exist in the Bahraini PDPL against the GDPR are filled out.
Thank you. We have a question here on data transfers. The question is Bahrain likely to be considered adequate by the EU in terms of data transfers because of the PDPL?
Yeah, sorry, there's a motorbike outside my office. Excuse me. So if the answer is not immediately, the requirements to, for a country to make it to the list of jurisdictions of adequate protection in the EC is a fairly bureaucratic process and would require that Bahrain makes an application to the European Commission, etc., and establishes itself as being a jurisdiction with adequate protections. And I understand that the process will also require it to show that it has an active enforcement regime as well. So merely having the law on the books as it is now is not enough. I'm not saying that the law is not compatible with becoming a jurisdiction with adequate protection. It probably will be because a lot of the same features are there as you would see in many other jurisdictions, but the process to be recognised takes some time, as I understand it. So the answer is not immediately. So for people transferring data from Europe to Bahrain, you'll still need to look at complying with the relevant transfer provisions of the GDPR. So either standard contractual clauses or other derogations that may apply under the GDPR.
Thank you. We have a question about data protection supervisors. What will be the job description of a data protection supervisor?
Yeah, so it's very similar to a data protection officer. The idea is that it will be a person who helps the data controller exercise its rights or fulfill its obligations under the law, coordinates between the authority and the data controller regarding, application of the law to the data controller, verify that the controller actually complies with the law, notifies the authority of any violations, maintains a register of the processing operations similar to the Article 30 register in the GDPR. And importantly as well, the supervisor needs to be independent and impartial from the controller. So yes, like the GDPR, the controller can appoint a data protection officer, but it can't tell it what to do, can't tell him or her what to do. The supervisor must be acting independently of the data manager. So very similar to the GDPR.
And the related question that we have here is, do data protection supervisors need to be located in Bahrain?
I don't think it's that specific, but like I said, there is a registry and that the authority will publish, and the authority also needs to publish the specific criteria to become a data protection supervisor. So it might be that in that they say, and it needs to be, he or she needs to be resident within Bahrain. But on the law, it doesn't say, I don't think it says that.
Okay. Here's a question about data deletion. What is the deadline for responding to queries related to data deletion?
So that's not clear yet on the law. That will be one of those things that needs to be published through the implementing regulations that we were just discussing. There's no specific deadlines that I'm aware of in the law around deletions. Okay.
By the way, just to say, we're having very good questions here. Another question relates to cookies. Does the PDPL cover cookies/online monitoring?
It doesn't refer to cookies directly, but it does refer to automated processing. So it might be that through that, it considers that automated means of processing via, for example, cookies could be caught. And in that case, you still need to notify the authority. But there's, again, from what I can see, nothing like the monitoring requirements in the threshold of monitoring being a behavior that of itself catches you under the PDPL. But to the extent that the use of cookies can be seen to be a form of processing personal data, then yes, you would be caught under the PDPL. But again, I expect that the authority, maybe not immediately, but in time, might make further clarifications around those points.
A question about when the DPA would be in force. What date will this be established?
Mohammed?
The Data Protection Authority being established, there's no, obviously it needs to be before when the PDPL comes into force in August. So it will be sometime between now and August 2019. We don't have a specific date. We're regularly in touch with the relevant authorities on this, and the relevant authorities that are working to establish the PDPL. They haven't yet commented. They don't want to comment off record or officially because they themselves are it's new territory for them. So honestly, we don't know, but in the coming months, I would say so. Generally speaking.
Okay. We have another question here. Is there going to be an agreement similar to Privacy Shield between Bahrain and other countries that already have laws in place?
Sorry.
Go ahead, Eamon. Eamon, go ahead.
Okay, thanks. I think the answer is we don't know. Maybe that's what you were about to say, Mohammed. But sorry, just to explain, Mohammed and I are in different countries right now, so we're not we're on the phone to each other as well. We don't know yet. Again, it's something for the authorities to do when it is established. It remains to be seen.
We have a question now about a particular provision in the law. It's Article 2.4, which, as written by the person asking the question, excludes family and personal matters. The law doesn't define them. So to what extent does this exclusion apply?
Mohammed?
Sorry, Toks, it got cut off a bit. Can you repeat the last part about exclusion?
Certainly. It asks, to what extent does this exclusion apply? The exclusion concern in family and personal matters, I should say. That's Article 2.4 of the PDPL.
Yeah, I think. So I think this is supposed to capture, for example, mums and dads, etc., using personal data on a day-to-day basis for the purposes of just conducting family life. And so, for example, using somebody's details for the purposes of applying for a passport or registering at a school, etc., won't be considered data processing under this law. So it's just a carve-out. Again, it remains to be seen how it will be applied, but I think its primary focus is just to somewhat narrow the scope of application to avoid it capturing absolutely every aspect of life. Equally, it could also be a way of further protecting the privacy of families on a day-to-day basis and avoiding, for example, complaints being made to the DPA and the authority in relation to things that it otherwise wouldn't have any jurisdiction over. So, it remains to be seen, but I think it's a common sense approach.
Okay. Moving on from family matters to financial matters, we have a question about banking. So from a banking perspective, what sort of customer data is considered as confidential in the PDPL?
To be honest, Ayman, to be honest, when it comes to banking, almost everything is confidential. Because whether you're applying to loans or you're updating your KYC or you're doing any credit search or authorization to do the credit search and credit ratings. So generally speaking, banking and the financial sector will be heavily regulated by the PDPL because one of the main, I remember I had a discussion a few years ago with the Central Bank of Bahrain. One of the main scrutinies that the Central Bank of Bahrain came on international is that we don't as a jurisdiction, we don't have a standalone data protection law. So generally speaking, I think to be on the safe side, I would keep almost the majority of the information, not all of the information, to be under the governed under the PD to be protected, honestly. And you will need written express consent by those owners of the data to process their data.
We have a question now from someone who is concerned about the lack of guidance from the Data Protection Authority, and they simply ask, what advice would you give, I think in addition to what's already been said, to help organizations prepare for the PDPL? Okay.
So I think that relying or waiting for guidance from the authority, I mean, you could take a wait-and-see approach, but I suspect that the details that are required to be published by the authority to implement the law aren't really the things that you need to worry about in terms of implementing an overarching framework. They will be primarily details. So I think what's important is that, as I mentioned earlier, you take the steps necessary to assess your current use of data in the organization. And once you take that audit, then figure out what the gaps are against the major points in the PDPL. So, for example, are you collecting and using data in accordance with Articles 3 and 4, which are around the transparent use and collection of data and the appropriate bases for processing? Do you use consents to process data? And if so, do you comply with the relevant article of the PDPL when you do that, collect that consent? Do you have a privacy notice that's sufficient in terms of its explanation? Do you have a privacy policy on your website, and so on? So these are steps that you can take now without necessarily worrying about the authorities' further guidance, because the experience that we've had based on Europe and the GDPR and European data protection over the last 20 years and other places should inform how we proceed with complying with the PDPL now. So I think you'll be able to do a lot without waiting for the authority.
Thank you. I'm going to merge these two questions together. The first question is, do you think that the PDPL will be an inspiration to other countries in the Middle East to adopt new data protection laws? So that's the first part. The other part asks whether this law is similar to the Qatar DPL law number 13 of 2016, or whether it's similar to other provisions in GCC countries like the UAE. So let's begin with the first question, whether this law would be an inspiration to other countries within the region.
Yeah, and Mohammed, feel free to follow up with your own views, but I think yes. I can tell you that we are aware of we've become aware that the UAE is considering some form of this. When and how, what it will look like, we don't know yet, but there's been discussions about this for quite a while, and similarly with Saudi Arabia. So I think definitely, as countries have been considering how to diversify from oil for a while and how to digitize their economies and move into an e-commerce digital space, it's only a matter of time before a data protection law is required for that. But I do think that Bahrain, having published its law, has upped the ante for everybody else to do this sooner now than later.
I completely agree, Eamon. I think it would have a knock-on effect on the rest of the GCC, trying to looking at neighboring countries, because this region, they act like one, honestly speaking. So whenever one of the countries, neighboring countries, come up with a regulation or a way of, let's say, they're going towards the digitization of their economy, Vision 2030. Saudi has it, Bahrain has it, the UAE have Expo 2020. They try as much as they can. They develop to make this region a developed jurisdiction, developed region. So I would say yes, of course, it would help other countries, and it will, let's say, encourage them further develop their legal legislations and legal systems to promote FDI within their respective jurisdictions, foreign direct investments, and also build confidence around investors, foreign investors.
Thank you very much. I have to say that we've received a very positive response in terms of questions. Unfortunately, due to time limits, I must move on, but I do thank you very much, listeners, for your very interesting questions. Now, to move on, can I just perhaps encourage our listeners that there is more information? Eamon, could you just tell us a bit more where we could get more information about data protection in general, data protection within Bahrain, or perhaps within the region?
Yep, absolutely. So we have a dedicated data protection practice internationally, and that includes throughout the Middle East as well. And just going to the other the other question that you had in relation to how does the Bahrain law compare against the Qatar law, for example, we've produced a website which contains a handbook of data protection laws, not every single one of them, but most of them, or a lot of them, from around the world. And on this slide, you'll see the website name and a map showing the jurisdictions that we cover. What's pretty cool about this product is that you're able to compare themes of one country against another country. So you could, for example, go to the page we have developed for Qatar and compare it against Bahrain in relation to, for example, the consent requirements in that law. And so, yeah, that's a very, very handy resource we recommend, and it's freely available, so there's absolutely no cost to that, and quite a good, useful tool to get an initial view on the laws of various countries around the world. We also have, I think in the next slide, a number of other free online resources that you can avail of. So we have a regular blog called Privacy Matters, shown there at the bottom middle, and a number of other tools that you can use just to get a very quick sense of where your organization is, not in terms of specifically legal compliance, but it's the organization's maturity with respect to how it treats data. That's in the data privacy score box in the bottom left-hand side there of the screen. And finally, we have, if you would like to look at the GDPR, quite a nifty app you can download from the Apple iOS store or Google Play, which allows you to download the GDPR, but also it's an interactive tool that allows you to compare it with the previous European directives and the GDPR recitals, so that you don't have to go searching for all of those things when you're looking at the current GDPR. So we have a suite of tools that can be used to assist you in understanding your data protection requirements.
Well, thank you very much. In addition to DLA Piper's online tools, we at Data Guidance also have very wonderful tools to use. Do sign up for a free trial of Data Guidance. You can contact Patrick Coupland. The details are, of course, on the screen. And in addition to our daily updates, to opinions, legal research, videos, etc., we have our cross-border charts to help you review and compare regulations across multiple jurisdictions at a glance. And each topic is supported with in-depth guidance notes. We cover areas such as data transfers, direct marketing, employee monitoring. We also have, of course, charts on the GDPR, the new California Consumer Privacy Act, the CCPA, and we have a global privacy directory, which is a very useful way to get a snapshot of data protection laws across the globe. So go on and sign up. This brings us to the end of the webinar. Remember, it was entitled Bahrain Personal Data Protection Law. And I would once again like to thank Mohammed Tarani, the head of DLA Piper's Bahrain office, and Iman Holly, the legal director, intellectual property and technology, based in DLA Piper, Dubai. Of course, thank you to all our listeners, and I hope you found this webinar as insightful and interesting as I have. Once again, I'm Toks from the Europe, Middle East, and Africa analyst team here at Data Guidance's headquarters in London. Thank you very much, and do take care.